Hello and welcome to Absolute Trust Talk. I'm Kirsten Howe, the host of Absolute Trust Talk. We're starting just a tiny bit late today. We had some technical issues, so if you've been waiting, I apologize. But here we are. We're ready to go. I am super excited about this episode because we're trying something a little bit different. It's still going to be interesting and helpful, I hope, but it might be a little more fun for me anyway than some of the episodes, because my guest, if you want to call her a guest, is our associate attorney, Madison Gunn. And so she and I are going to share with you some of our experiences in the world of trust administration. When somebody has a trust and they die, that process of all that legal work that has to happen is called trust administration. And we're going to be talking about some of the problems that many families bump up against when they're doing a trust administration. And these problems lead to additional expense, delay, and a whole lot of frustration for the trustee and for the beneficiaries. So we are hoping that by talking through some of these things that we see over and over again, we can help you and your family avoid some of those problems. And if you are not the oldest generation in your family, I'm especially talking to you. This is your opportunity to make sure things are cleaned up before your parents pass away and this whole problem lands on your desk. As you know, if you're a regular viewer, I got to do a little bit of housekeeping. First and foremost, we are recording this session, so it will be a video on our website, absolutetrustcounsel.com, in a few days. It also will be a podcast, which is just audio, also on our website in a few days, absolutetrustcounsel.com, and also wherever you listen to podcasts. If you listen to them on your phone, like I do, that's where you can find this episode. So if you want to watch it again, or you want to tell a friend about it, that's what you do. You tell them, go to absolutetrustcounsel.com and it'll be there. Okay. Now, the other thing is we do take questions at the end. Madison and I will talk for a little bit, and then we'll take questions from the audience. So at any point while we're talking, if you have a question, just type it into the comment section and we'll get to it at the end. All right. So as I said, my guest today is Madison Gunn, our associate attorney. Madison has been with us for a few years now, and she has worked on every trust administration that's come into the office in that time. So she's done a lot of trust administration work, and she has seen a lot of these issues that we're going to talk about today. And I have done even more trust administration. I know you will find this shocking, but I'm a little bit older than Madison, so I've done a few more than she has, just by virtue of my advanced age. And over the years, we've seen many of these cases, things that could have been avoided. If the family could have done something, should have done something, and they just didn't. So this is our hope, is that we're going to help you all avoid some of these problems. All right. So Madison, welcome. I'm so happy to have you here. This doesn't feel as nerve-wracking or stressful for me to have somebody who, I don't know, somebody who I talk to every day. Maybe that's it. Let's start though with the most common failure by far that we see, which has to do with funding. So funding, when you have a trust, you actually have to make sure that your trust owns assets. It doesn't happen magically by you just thinking about it. You actually have to change title on assets. And that is by far the most common problem that we encounter in a trust administration: assets not being in the trust when our decedent passes away. And it's if it's a bank account, we can deal with that relatively easily. But if it's real estate, that's where it gets really to be a problem, because then, well, it's a problem. Madison, you want to start by kind of talking about the different things that could cause real estate to not be in a trust?
Sure. So I know the big thing that we see on a regular basis is, and this just comes up with normal estate planning, not so much with trust administration, but people, when they refinance their homes, most people aren't trying to stay on top of that escrow and title company to make sure that everything is handled. But a lot of times they will make you sign your house out of your trust in order to sign that refinance paperwork. And if they don't have you sign a deed putting it back in, we say it fell out. It fell out of the trust. And people don't notice. I noticed that a lot of people don't think they even have a deed to their home. They treat it like a car title where you don't get the pink slip until you pay off
Until
the
you
mortgage, pay off
right,
the loan.
right.
That's not the case with a house, but if you've purchased a house, you're not the one signing a deed. So you probably don't even realize that it's in that stack of paperwork that's sitting in the bottom of your file cabinet.
Right.
So
That's a very common misperception when I ask people, do you own any real estate? And they say, well, no, the bank owns my
right.
home. No, you own it. Yeah.
Yeah. So that's a big one when people refinance their homes. They don't realize that they have to stay on top of it. And a lot of times people they don't know what they're doing. They're not mortgage brokers and escrow. I wouldn't know, that
Right.
you have to stay on top of someone and make sure that the vesting stays the same from the original deed to the current deed.
Yeah. So if you are doing a refinance, which, everybody and his brother has done a refinance in the last 2 years for sure. It's a question to ask, are you taking my home out of my trust? Because not all lenders do that.
Right.
Some have another way of handling that situation, but that's pretty common that they do.
Yeah.
Yeah.
It's getting better for certain as far as lenders allowing you to refinance in the name of your trust, and that they've realized that a trust is not some, archaic thing that designed to keep everything away from, taxes or the
Creditors. Yeah.
government, the creditors. Yeah. So it's gotten a lot better. But I mean, even if you refinanced 15 years ago, some people don't refinance every 2 years,
Right.
and so they've just fallen out. And as a part of our estate planning, we routinely check
Yeah. Yeah.
deeds, people who have existing trusts. So that is something to certainly stay on top of
Yeah.
when you're
Yeah.
doing a refinance.
Yeah. We will catch it if you come to us to do updating, but if you don't, it might not get caught. So you need to think about that. Yeah.
Yeah. The other big one is an inheritance. If you're inheriting property from your parents or an aunt, uncle, grandparent, whoever it may be, a lot of times the attorney doing the trust administration is just going to ask how you want to vest on title. And if you don't know what that means, or you're just like, well, it's just
Right.
mine, put it in my name, then they just give it to you as your, a single person as their sole, or a married person as their sole and separate property, however you choose to be on. But that doesn't put it in your trust.
Right. Right. You have to
And
take that next step and do another deed to put it in your trust. Yeah.
yeah,
Or if you are in the process of inheriting real estate, just tell the attorney who's handling that trust administration. Oh, by the way, I have a trust. Is there any way you can put that in my trust for me? Yeah.
right. And you can check with if you're not sure, check with your estate planning attorney that did your documents or your current attorney and say, hey, I'm inheriting. What should I tell them? And we
Right.
can, they could be directed to their certificate of trust or their trust document to say this is exactly how your title should read.
Right. Right. Yeah. And same goes with if you're purchasing new property.
Right.
You already have an estate plan, you already have a trust, and now you're buying a vacation home, or you're buying a new rental property, or you're buying a new home. You need to, we've had that happen too. Where
Yeah. It's kind of a combination between the refinance and inheritance. You got to tell them how you want to be title. You might be able to do the loan in the name of your trust, in that sense, to where it's just all handled that way from the start. If not, then you have to follow up and make sure that they're putting it in your trust as well.
Right. Right. That's a good point. It's going to depend on the lender that you're using to buy that new property, whether they'll do that for you or you have to follow up and do it yourself.
Right.
But again, you go back to your estate planning attorney and they'll tell you what you need to do. And so what we haven't talked about is what happens to these trusts when the real estate falls out.
So it depends.
Of course.
So if the real estate was owned at the time the trust was created and it's listed on that fund Schedule A that everyone obsesses over at the end of their trust, and it's not in your trust after someone dies, they can file what's called a Hagstat petition, which allows you to put whatever was on that Schedule A into the trust. It's essentially a shorter version of probate. And if they don't have anything on that Schedule A, or if it was acquired after the trust was created and is not in the trust, then you have to do a probate for it. And the unfortunate part is that probate fees are calculated based on the fair market value of the property. The probate court does not care about a mortgage or a lien or any type of encumbrance on that property. So they will calculate it based on the full amount. So
yeah. So it can be very expensive, and probates take a long time. People get so frustrated with how long probates take. So, so that's really a terrible mistake. You went to all the trouble to set up an estate plan that included a trust in order to avoid probate.
right.
And yet you end up having to do one anyway. So keeping an eye on the real estate is really important. Really important.
Yeah, that's a lot harder to get around. I think the get around for real estate is if it's worth under $50,000, which that doesn't exist in California really. So it shouldn't even be a thing.
Well,
it's false hope.
Yeah, right. It gives people false hope. Okay. All right. So kind of similar to the failure of funding, another common thing that we see is a failure of beneficiary designations. Some assets that clients have don't go into a trust. We don't want them going into the trust. And I'm thinking primarily about the retirement assets because those are pre-tax dollars. We don't want to mess with that pre-tax situation. That's nice. So they don't go into the trust. They pass by what's called a beneficiary designation. And we've seen over the years many examples where the beneficiary designation fails for a variety of reasons. You want to talk about what happens in those cases, well, how it fails, and then what we have to do?
Sure. So when clients don't list a beneficiary, then the default is that it goes to their estate. And the fun tip and trick is that estate means probate, typically.
Exactly.
So in order to get any information about that IRA or 401k, you have to provide letters of administration. Anytime you see someone asking for letters, that means that you have to file and open a probate. And again, that typically would also mean, and that may mean that it goes to the right person anyways, but that also means that it has to be liquidated and you don't have any type of control. I know control is limited more so than it was before 2019, but it's still more control than what a probate would grant you. So as far as you're controlling taxes and how you choose to withdraw that with the probate, it's just, you don't have a choice. It's cashed out, taxes are due, providing accounting takes forever.
Right. And so that happens if you think about how much money just gets taken right out of there, on the liquidation, paying the probate fee, paying all the income tax that's due on that whole account. Maybe it's a $300,000 account. If you added $300,000 of income to your 1040, think of how much tax you would pay on that. That's a lot.
And if for some reason the natural beneficiary through the probate is someone who would have received the stretch that the Secure Act allows, like with a person within 10 years of your age, or, a special needs person, you would lose that.
Yeah, you are accelerating that tax bill unnecessarily. And so these kinds of things happen, that there's no beneficiary. Probably it's either the person didn't fill out the forms at all, or it might be that the person they put on the form died first.
Right. Or account changed custodians and they lost the paperwork, because that is on you as the owner of the account to make sure that they have a current beneficiary designation. So even though you've been married for 50 years and have 3 kids and your natural beneficiaries are listed in the order you want and you don't have to change anything forever, you still need to check that every year, because if they lose that designation, they're not going to take the blame for it, because they're not going to administer it without it.
Right. You're going to have to just follow the process, meaning, some kind of probate situation. Yeah. Okay.
Yeah.
Ooh, yeah. And we really don't like to see, we really don't like to see that. That's the worst, having to probate an IRA or a 401k.
Yeah. I mean, and another issue is when they don't understand the forms and list the wrong people. Sometimes people will bypass a spouse or even bypass their children, not understanding the beneficiary designation forms. And there's certainly no problem asking your estate planning attorney or your financial advisor for help filling out those designations.
Yeah. And that's always better to get help than to try and get it wrong. Yeah.
Yeah.
So ask questions first. Okay. So now I want to talk about a particular variety of failure that results from not updating your estate plan to match your current situation, and focusing again on the real estate. Madison, you know what I'm talking about, but it's like sometimes the client's situation or relationship to their real estate changes. And I'm thinking in particular, like now you have somebody besides yourself living in your real estate, and that person isn't, that living arrangement isn't addressed anywhere in your estate plan.
Yeah, absolutely. We've seen a few different, I don't want to say excellent examples. It's an unfortunate way of putting it, of this recently. One where, a family member, although it doesn't have to be a family member, moves in to take care of the homeowner. And the homeowner promises, you're going to get this house. You've quit your job, you've sold your house or broke your lease to come live with me and take care of me. You're going to get this house.
Yeah.
Unfortunately, dying bedside promises in the world of our current estate planning laws don't mean anything. You have to put that in writing, executed the proper way. Otherwise it's not going to work. And we see clients who are trying to administer trusts where the house might be the only asset, and all of a sudden there's 2 or 3 other beneficiaries on there, and they can't buy someone out. They've been out of a job. All they have is retirement. They're on a fixed income. There's no way to, finagle that in order for them to get the house. And it makes it difficult.
Yeah. So I guess maybe a common scenario there is, let's say there are 2 kids, and when mom created her estate plan, she said everything equally to my 2 kids. And that would have been just great, 20 years ago. But now mom has been over the years spending her liquid assets. So there is not enough liquid assets to give 1 kid the house and 1 kid all the investments. And now you're in a situation where you have this 1 kid who's living in the house and wants the house and really needs the house, but there's not enough money to offset so the other kid gets an inheritance. And so that's like gradually over time, the financial situation changed, and that needs to be addressed in the estate plan as well. And
right.
It's not, yeah.
And now they have to address the Prop 19 issues in California in terms of property taxes, because if the child who's receiving the house really needs it, and most likely might not be able to get a mortgage, or obtain a loan of that nature, probably also can't pay for like a 2,500% increase on their property taxes.
Right. Yeah, they would be okay if the property taxes were $1,500 a year, but not if they're $20,000 a year. Yeah.
Right.
Yeah. Which is not far-fetched. people.
No.
This is
Yeah.
what's happening. This is what's happening. So,
And we've even seen that with, grandchildren that are living in the house.
sure.
And that's one thing, that grandchildren don't get to keep that tax basis unless a very specific set of circumstances occur. I mean,
Yeah.
99.9% of the time it doesn't occur. So,
Right.
you have to plan for that as well, if that's how you want your home to be distributed.
Right. And the other thing I would say about, someone else living in the real estate, even if it's a situation where you don't necessarily want them to um, inherit it, I'm thinking of a lot of our clients. They are in a second significant relationship, but they're not married, or even if they are married. But this is my house, my new significant other, or my new spouse. I want them to move in. I want them to live with me, but it's still my house. And when I die, it's going to my kids. And everybody's okay with that. But I say you've got to take into account that, well, what if you become incapacitated? Now we have to say in your trust, this new spouse is allowed to live in my house. Even though I'm not the trustee anymore, I'm incapacitated. I want my trustee to allow my new spouse to live in my house.
Yeah.
Even
And what if you can't live in there? What if you're in long-term care?
right,
Yeah.
right. And so, I mean, the other thing is, yeah, if the house is going to be sold, needs to be sold, the beneficiaries want to sell it, let's at least give that person 6 months to find a new place to live, something that is kind and compassionate and makes sense for the family. So those are the kinds of things that we have to um, address and update the estate plan.
Yeah. And that's extra particular if you are not married and you
Right.
share a home, and especially if you own that home yourself and you're still married, your spouse does not have a community property interest because there's no marriage. That a community property interest and what you're entitled to only happens if you're married.
Right.
So those are all very important things, regardless of age,
Right.
regardless of that, it still can be, people talk about marriage as being that, well, if you get divorced, you lose half. And it's like, well, if you're not married, you might lose it all. So
Yeah.
it just kind of depends on the way you look at it.
Yeah. And depending on your relationship with the children of your significant other, they might say, you are out of here now.
Right.
We're not giving you 30 days. This is our house. Go. So it's very important to put in writing what's supposed to happen. And a lot of people don't think about that. They just, when you have a new boyfriend move in, you don't go, oh, I better call my estate planning attorney. People don't think about that,
No.
but we need to.
Right. Cohabitation agreements is for another day.
Right.
Yeah.
Right. Exactly. Okay. So, Madison, is there anything else you want to say about any of those before we go to the questions?
No, I think that's it. The big takeaway, I think, is always make sure how everything's titled. And if you're going to make promises, make sure you follow through with your estate planning attorney.
Right. Yeah. Okay. So let's see. Our first question: should you put real estate that's not in California in your trust?
Sure. Why not? It depends on what your purpose is, what that real estate is. I mean, if it needs to be in an LLC or something like that, it might be a little bit different, but you can certainly have out of state real estate
Yeah.
in your California trust. It just means that California law is going to prevail to the extent that there's any issues with the trust.
Right. And the other important point is if you don't put your non-California real estate in your trust, there's going to be a probate in that jurisdiction.
Right.
So, if you have a vacation home in Colorado, there's going to be a Colorado probate when you die,
Right.
unless you put it into your trust, which that's always a fun thing
Right.
to have to tell the family, oh, we're doing a probate, not in California.
Right. Now you have another attorney.
Right.
a whole other, because most attorneys
Yeah.
don't practice in multiple states. So
Right. Yeah. So if that doesn't scare you enough, the thought of having two attorneys in your
right.
life, I can't help you. I'm sorry.
Right.
Okay. Okay. So can you name your trust as the beneficiary of your IRA?
So you can. It may or may not be what you want. It depends on the situation. Um, we like to avoid doing that just for tax purposes. So you don't want to,
Right.
you don't want to pay more taxes than you have to. But if you have very small children, and they're going to be the beneficiaries, then yeah, you'd want control, right? Because you don't want them essentially to get that money at 18.
Right. Yeah.
Or a special needs person is your beneficiary. You don't want them to get that money outright and lose their benefits. But most of the time, you're just typically listing people as the beneficiaries for your retirement accounts.
Yeah. That's an analysis that you really have to do. And it really depends on what is the most important thing. And if control is important, the only way you can control with your dead hand is with a trust. So,
Yeah.
so that might be appropriate. Okay, now here's a question about one of our one of our favorite topics. What about safe deposit boxes?
No, just get rid of it.
Should they be owned by your trust? That's it. I mean, that's a good question. Should they be owned by your trust? If you have one, what do
Yeah,
you think?
that would be helpful because
That-
whatever power of attorney you have on file with the bank, that dies with you. So the only way they can get into that box is if they have the key and they're just taking an inventory. Otherwise, the bank's going to require letters. And remember, that means you have to file a probate. And it would be horrible to file a probate, go open that box, and there's nothing in there.
Right. There's just a couple of pieces of paper that mean nothing. So I think a lot of people don't appreciate this whole concept of what happens with your safe deposit box when you die. But so what Madison, you're saying is you have, in order to access the safe deposit box in a way that means you can open it and you can take the stuff out of it.
Right. And close the account.
You
Stop
have
paying for
to
it.
you have to both have the key and be a signer on that account. Most people don't add their kids onto their safe deposit boxes. So an approach would be to own it through your trust. That way, when the successor trustee steps in, they are an owner on the account. But these accounts, they cause more trouble than
I think they're going away. Like it seems like the banks are getting rid of them. So, I mean, hopefully it might not be a problem in 15, 20 years, but there's still the generation out there that
sure.
very much, I mean, that's where that deed they don't think they have is most likely
Right.
also.
Right. Yeah. And just a little side note on safe deposit boxes. If you have one, you like it, you want to keep it, don't put your estate planning documents in there because then nobody's going to be able to get them. So it's okay to put them in there, but make sure that you have another set outside of the safe deposit box. Don't put your only set in there. Okay. Anything else you want to say about safe deposit boxes?
Maybe, but probably
Yeah,
not.
but I know. We don't. If we have any bankers watching, we don't want to get too carried away with ourselves. Okay, so we have that's all the questions that we have in here. We have so many more of these trust administration fails, mistakes, boo-boos, whatever you want to call them, and we probably are going to have to do at least another episode together to share all of our information. But that's a good start. We don't want to overwhelm you.
Yeah.
The main thing is you got to keep things up to date and you got to dot all the I's and cross all the T's. So, okay. Thank you, Madison. This was fun. I hope you had a good time too.
Yeah. Thank you for having me.
Of course, anytime. All right. And thank you all for joining us. I really appreciate you being here and I hope you got a lot out of it. if you like our podcast, please go to iTunes and subscribe. If you want to look for it, you just type the words Absolute Trust Talk, or you can type my name into the search on your podcast icon button, and it'll come up. Liking our podcast, subscribing to it, those kinds of things, that really helps with our search engine optimization, otherwise known as SEO. So we appreciate that. And you can always find our episodes and everything that we've done on our website, absolutetrustcounsel.com. We have lots of episodes, lots of other things. We have blogs, we have newsletters, all kinds of things. So we're just trying to be helpful, get as much information out there as we can. And make sure you catch our next episode in a couple of weeks. I know you'll get a lot out of that one. And thanks again. I really look forward to connecting with you next time.